Do you know when the IRS can abate interest? I'm Andrew Bosserman, tax attorney and founder of Boss Tax Law, and in this video, I'm going to discuss when the IRS can abate interest on taxes owed. So, a common question I receive from taxpayers is interest owed on tax debt. Is that able to be abated by the IRS? And the interest can be on underpayment of taxes. It could be, an outstanding penalty. I've talked in other videos about how to qualify for and request abatement of penalties. And generally, in those instances, you can rely on what's known as reasonable cause. But the abatement of interest is different. It's specifically in law, and it's only applies to a very specific set of circumstances. Essentially, in order to qualify for abatement of interest, there must have been an unreasonable error or delay on behalf of the IRS. So there's a few examples the IRS gives and in cases, but essentially unreasonable error delay means that there was an employee or a portion of part of the IRS that was supposed to do something, take some action. They actually refer to it as a magisterial or a ministerial activities, but those are big words for essentially meaning some sort of administrative function. But the IRS was supposed to do something and they didn't, and they caused an error or delay that led to the interest compounding over time. So one of the examples the IRS gives is that a taxpayer sent into them records, but the IRS received the records, lost them, causing a big delay and interest to accrue during that period of time. Another example is that there was an agent assigned to a case, but that agent had to go away for training or took a leave of absence. This is really common. When I was an IRS agent, we would have training for 1 or 2 months at a time, and our cases would just sit at our desk with nothing happening. In that situation, the IRS can abate interest. But it's important to know that even if there was an unreasonable error or delay on behalf of the IRS, essentially the taxpayer who owes the money can't be at fault. The error delay can't be, due to any actions of the taxpayer. So you want to make sure that's really just the IRS that caused the issue. And if you think you might qualify for abatement of interest based on these facts and the law, you must request abatement in writing. So you can write a letter, but generally it's preferred to use Form 843. And that tax form, it's a form available on the IRS website, and it's often filed for penalty abatements, but can also be used for abatement of interest. So again, in summary, very narrow facts to allow abatement of interest, but it is possible in some situations. Essentially, it must have been in a reasonable error or delay by the IRS, and the taxpayer was not at fault whatsoever. So if you think that you qualify for an abatement of interest or have more questions, feel free to reach out, and I'd be happy to help explain more and see if you qualify.